skill-oriented, ethics-based. There are methods which are being introduced, what we have borrowed from medical education, the concept of clinical learning. This is based on experiential learning, learning by doing. And there are methods, institutions in society which can help the student to learn the skills required for lawyering, whether it is in the alternate dispute resolution mode or in adjudicative processes. There is need for interdisciplinarity. A lawyer is supposed to know as much of knowledge as outside his field of law to be able to address questions of law. This is an age of specialization. Unfortunately, our legal profession has not developed, excepting after the liberalization of the economy. There are now lawyers who are mainly based on mergers and acquisitions and things like that. But for the ordinary man, can a lawyer meaningfully practice law on one day in the tax court and the other day in the family court? I do not believe so. It requires a tremendous amount of understanding of human nature and the nature of the disputation, the social context in which it has arisen, to be able to give meaningful remedies or justice. In other words, there is time for specialization, there is time for interdisciplinarity and methods of understanding disputes in social context to be able to give quicker and meaningful remedies. Examinations in law schools, you know it better, it doesn't test your skills or your understanding, your capacities to be able to address the issue. I do not want to go into that. But the point is that when Civil Procedure Code was amended with the intention of expediting justice, Section 89 was introduced in the Civil Procedure Code, compelling every judge that in the first hearing of a civil suit, it must be attempted to be settled by alternate methods. Why is it not becoming, of course, initially the lawyers went on strike when this was introduced, and three years nothing could happen. Is the legal profession today, I was telling Elizabeth in the morning, has been obstructing the course of justice. The Parliament in its wisdom, after ascertaining the will of the people, have amended the Civil Procedure Code to compel and make it a requirement before a trial is started that see whether it can be settled by mediation and other ways. But it has not been attempted. Even in the Criminal Procedure Code, Chapter 21A, the institution of plea bargaining was introduced, whereby all offences up to 7 years of imprisonment could be settled by the process of bargaining. But hardly any, even today I hear judges telling that plea bargaining is unethical. Can a lawyer or judge conscientiously say so when Parliament in its wisdom has amended the law and made you implement it? But instead of implementing it, you are criticizing it as if that is no justice. This is the people need to understand as to why is it that despite 6 years having passed of plea bargaining being introduced, it doesn't happen and people suffer imprisonment beyond the period to which they could be sentenced if they are found guilty. I submit that a pre-entry training for particularly the legal professionals will have to be there. Nowadays, Bar Council is thinking in those terms, because all that is required to train a lawyer cannot be given by any law school anywhere. So much so, all over the world, before a person is licensed to practice, he is required to be an apprentice for a certain period of time, and then the Bar Council has to conduct an examination and he has to be qualified and then only allowed. But here, nothing of the sort. So therefore, a pre-entry training and an examination at the end, whereby you are reasonably sure that if the person is entitled to deal with the life and property of other people, he is competent for the work. This is the function of the Bar Council. It doesn't do so. I would even, I have seen in South Africa, the Bar Council in association with selected law schools have organized a program for pre-entry training 6 months duration, very intensive. As a lawyer does in a law office, the fellow is asked to form himself into a partnership, live cases with them, which are happening in the local courts, and do all that, whether it is affidavit or pleadings, will have to be done as a lawyer does. Even the accounts of the clients have to be maintained and be responsible for anything going wrong. This is all simultaneously done in an understanding with the local law firms under the supervision of an experienced lawyer deputed by the Bar Council. Such a model as it exists in South Africa, in New Zealand, will have to be there before you can license a lawyer to practice in a court. Continuing education. After all, knowledge is exploding. And if you cannot have continuing education, the license will not be. In America, you cannot retain the license if within a certain period you do not get additional credit for having learned from a law school or other places where in the area of your practice. Therefore, continuing education for lawyers and judges. Believe me, when I went for the setting up of the National Judicial Academy in Bhopal, which is intended for training of High Court judges as well as senior district judges. So Chief Justice told me which High Court judge will come for your training. The government of India spent about 112 crores for setting up a beautiful campus in Bhopal. So it was with some diffidence in 2003. Today I can tell you with confidence that High Court judges are coming repeatedly and are wanting, there is a demand for learning on the part of High Court judges. So, we have gone to such an extent that in 1 year, there was a course organized. Welcome. Sorry. We had a week-long course organized for Supreme Court judges, and the Supreme Court judges wanted it to be repeated. In other words, I am telling you that continuing education is a felt necessity for better, speedier implementation of justice. My last submission, to be able to complete in time, is that a model which I thought, which was not in my mind when the National Law School was set up. I believe that in the interest of faster justice, fairer justice, we need to allow a sort of a diversification in the law school. Those students who want to have a judicial career, after the 3rd year of their law study, by which time they will have picked up the knowledge and basic skills, allow them to go into a stream in which you will teach judiciary or administration of justice related subjects. And that can be extended for 1 more year. So 2 years of study of judge related, because what are the judicial judges' function? Judges' function is to ascertain facts from all types of competing arguments, evidence. Judges' function is settlement of issues. Judges' function is to appraise the law and interpret the law. Judges' function is to write the judgments and orders. Train them in the law school in those subjects along with the other subjects in the next 2 years of the 5-year law course. If necessary, take another year and then allow them to take the judicial service examination. Appoint them as judges. You are reasonably sure that the fellow will be effective and will not be adjourning unnecessarily. He will be able to understand the arguments. One of the complaints which lawyers make is that the judge is ignorant of the law. However much I try to argue, repeat it, it doesn't go into his head. What do we do? So this is to be appreciated. If several lawyers were to say that, you have to find an appropriate remedy for that. So that is one stream. Another stream could be the litigating lawyers. The litigational skills are different from transaction, documentation, research and other skills, negotiation. So one stream of litigating lawyers, next 2 years will specialize and they will be good for adversarial adjudication. Another stream can be for mediators and conciliators who will do that and develop the skills therefore and will become that. It's a need for specialization in LLB education, in professional education from the 4th and 5th year in order to develop the competent people with character and integrity to be able to occupy the offices in administration of justice. This is good investment. This can be attempted in good law schools. You will have a cadre of trained lawyers and trained judges who would be able to dispense justice much quicker and much more effectively with less appeals if this is attempted. Because I believe that whatever technological or other reform that you can bring in, if the human material which is commanding the system are not sufficiently tuned and trained, nothing will come out of it. The system will go on and finding excuses one or the other. So let us invest in education to get the results that we are looking for. Thank you.